Hello, my name is Tim Eaton. I'm a partner at the Chicago law firm of Taft Stettinius Hollister, and I have practiced in the appellate area for about 40 years. And what I want to talk to you today are two things. One, when you should appeal, and two, whether you should appeal. Let's talk first about when you should appeal. Many of you have watched television shows and I dare say in some of the movies where as soon as the adverse verdict comes in from the jury, the lawyers shout, "We're going to appeal, we're going to appeal." Well, it's not that easy and you shouldn't be making that decision so fast. But let's talk first of all when you can appeal. First of all, it has to be a final judgment before you can appeal. And that would mean that if there's a verdict rendered, you have to wait until all the issues have been decided by the court, because there may be an additional issue of attorney's fees in the civil case, or there may be some post-trial motions filed. And after the post-trial motions are filed and they're ruled upon, at that point you can appeal. Or, for example, a summary judgment that has been entered against you that disposes of all the issues. That gives you an opportunity to appeal. Or a motion to dismiss that's been dismissed with prejudice and there's no opportunity to refile. That would also present an opportunity as to when you could appeal. The second issue then is whether you should appeal or not. And it's not a second bite of the apple. The first thing you should consider is, were there errors that committed by the jury, by the judge? And you have to go through an analysis of possible errors that you could raise on appeal. The appellate court is not going to be hearing the entirety of the case again and rendering a second opinion. Its job is to determine whether or not you were given a fair trial in the first place. So you want to look at the various issues that occurred during the trial. First of all, you want to determine whether or not there were sufficient facts to support the jury's verdict or the judge's verdict in a bench trial. And there's two issues there. One is the judgment as a matter of law, something that should stand. So the analysis is whether or not there were any facts to support it, or was the judgment against the manifest weight of evidence, and therefore you should be entitled to a new trial. Look carefully at the record, and sometimes getting a second opinion from someone who is not involved in the trial, such as an appellate lawyer, would be helpful. Secondly, you want to look at trial errors. Was there evidence that was admitted that should not have been? You can take a look at that and decide whether or not that's something that would be a basis. You might look at damages. Were the damages supported by the record? Was it a runaway jury? These are the types of things you need to consider in deciding, first of all, whether you should appeal or not. So now you've covered when you should appeal and whether you should appeal. And let's talk about the considerations again as to whether you should appeal. So after you've identified the issues that would lead you to believe that you might have an opportunity to appeal because there are certain issues that the trial judge or the jury got wrong, you also have to consider the fact that there are certain standards of review. If it's an issue of law, then your chances are better that the appellate court is going to look at that with fresh eyes, because legal issues are decided on a de novo basis. But if it is an issue of whether or not there were sufficient facts to support the jury's verdict or the judge's decision, or in the case of summary judgment, the judge's decision, then you need to consider the standard of review, and it's a tough one. In cases involving a request that the judgment be vacated as a matter of law, you have to look at whether or not the evidence so overwhelmingly supported you that no jury could find differently. That's a very tough standard. Now, if you're simply going to ask for a new trial based upon the fact that you don't believe that the facts support the verdict, that's a little easier standard, but it still is significant. What you look at is whether or not all of the evidence was against the manifest weight of evidence, and therefore no verdict should stand. That's a tough standard to review. So just remember, you're not starting on a fresh slate when you're challenging whether or not there were facts to support the verdict. If you're talking about an evidentiary error, as I mentioned earlier, that you may have identified, there's two things you need to look at. First of all, That's based on an abuse of discretion standard. And abuse of discretion is not easily awarded because appellate courts do not like to second guess the trial judge. Secondly, you also have to show not only that it was abuse of discretion, but that it would have made a difference. If it was harmless error in view of everything else presented at trial, you are not going to get a new trial on an evidentiary issue that was called wrong by the trial judge. It has to be something material to your case and must have been so prejudicial that it did not give you a fair trial. So remember, in discussing with your client, even after you've identified an error, what the standards of review are, because those are critical. The next thing you may want to consider in deciding whether you should appeal and talking to your client is the costs. Quite frankly, if you have a verdict entered against you, the judgment interest rate that will be running while your appeal is in the appellate court is at 9%. That's a statutory rate. That's significant. Where else can you get 9% on your money? And that's what you would be paying during this period of time. Secondly, in order to pursue an appeal, you have to determine whether or not the other side's going to try to collect on the judgment. And if they're going to try to collect on the judgment, you're going to need a stay. A stay is going to need a bond, and a bond is obtained based upon the amount of the verdict as well as the interest that may run on the verdict for the time period of the appeal, which you might consider would be 18 to 24 months. I'd say in the Chicago area closer to 24 months, downstate it may be less time. But you have to consider what it's going to cost you, because there'll be premiums on the bond while the stay is in place, and it's going to cost you an amount of money just to have the status quo while you're on appeal. The other costs involved are the attorney's fees. You're going to have to discuss with your client that if you're the appellant, you're going to be filing two briefs, an appellant's brief and a reply brief, and you're going to be perhaps doing an oral argument. Although oral arguments are not entertained as much these days, it still is a cost that the lawyer will have to undertake in terms of preparation. So there's the cost of the appeal, there's the possibility of having to post a bond and the expense involved in that, and then there's also the time element. The time element is probably, as I said, 18 to 24 months in Chicago, perhaps less downstate. So those are other factors that you have to consider in deciding whether you want to appeal. Do you want to get it over with now, or do you want to take that chance to file the appeal? And remember, the appellate court is not there as a second bite of the apple. The appellate court is there to correct errors, both with respect to facts or evidentiary errors during trial that were significant and that were material and deprived you of a fair trial. So those are the issues that they will be looking at and determining what's next. So with all those considerations in mind, you and your client need to sit down and decide what the budget would be for an appeal, whether it makes sense to take it in light of the time that it may take to have the appeal decided and the costs involved, not only with the amount of interest that's running on the judgment, but your fees as well. And if you do finally conclude that it is worth it and a mistake was made and your chances of appeal are good based upon the standards of review, then you should go ahead and get ready to file your notice of appeal. If in trying to decide to whether or not you should appeal or not, and you want to look at substantive issues that may be addressed in your particular case, I would refer you to the various section councils of the ISBA. For example, if you have a family law matter, you might want to look at the family law newsletter to see what some of the current trends are. If it's a civil practice matter, Civil Practice Procedure Section Council has an excellent newsletter entitled Trial Briefs. And in those publications, you will see from time to time discussion of not only substantive law, but procedural. And I know I've written some articles for the Civil Practice Procedure Section Council on appellate practice pointers, and you might refer to those in making your determination and advising your client as to whether you want to appeal.